every criminal activity that an MP or an MLA indulges in, he can say, oh, it was meant for the vote. I was just on my way to vote. I ran over somebody on the road, but I was on my way to go and vote. The interpretation that I give is that it would equally apply to where a vote is not given or a speech is not made, because you could be bribed to do precisely that. If, for example, you go and you abstain and you're paid to abstain, then there is one valuable vote that is lost to the party who would have benefited normally by your vote being given. So it would equally apply. It's a concomitant, just like you've read freedom of expression into Article 19(1)(a) as a concomitant of the right to speech. This is a concomitant, the right not to vote, or where you have not spoken, but if you're going to be arraigned for that, you have to be secured. This, in fact, is in para 47 of Narasimha Rao, the minority judgment. In the middle of the page, Your Lordship, remember the sentence where they said our founding fathers could not have conceived of this kind of situation. So that court also frowns, the minority frowns on this kind of artificial distinction between one who votes and one who doesn't vote. So we commend that minority judgment, Malons, for Your Lordship's consideration. Now, if I can take a step back and just mention one thing, and this is there in both the special reference as well as MSM Sharma, the fact that the protections under 105, 194 are protections for the process of the legislature. These are not meant to be immunity protections for individuals who happen to be parliament. That's not the primary object of it. The object is to ensure that the legislative process is unimpeded by any kind of external force. So if a person is intimidated by the fact that I may be hauled up before a court for something slanderous or libelous, that person is deterred from freely expressing his views. For example, in Parliament, if you have to debate on something sensitive, like a minority issue or a caste issue, you may have to go into some sensitive facts. You may have to make statements regarding how people perceive certain issues, and many of them may be objectionable if said in public. But Parliament needs to do that because they are implementing policy via law. So you need to have that freedom. Now, this is not, I repeat, that kind of protection for the individual. It is for the legislative process. It is because the legislative process needs to be unimpeded that the instruments in that legislative process, who are these legislators, are given those immunities. Therefore, it is very clearly linked to the vote or the speech. Or, as Your Lordship sees in 105(3), it deals with other aspects apart from speech and voting, for which a law will be made. Until the 44th Amendment, it had adverted to the common law and said what it was in the House of Commons. But now we have said that it will be prior to that amendment. If I can pause for a minute and respond to the other point that Mr. Ramachandran made, which I've seen in the notes that Mr. Mehta has also submitted, that there are previous instances of Mr. Mudgal, then Mr. Subramaniam Swamy, who we're familiar with, and Mrs. Gandhi, Indira Gandhi, all of whom were expelled. And the argument appears to be that, look, Parliament has the power of expulsion. But we have to compare that with what is being argued today. This is about criminal prosecution. Now, if you were permitted criminal prosecution, its full sway, all the consequences that follow would attend that individual. We can't refer to that person as a member, refer to that individual, that accused. That accused would perhaps be convicted by a court of law, would have to face possibly a jail sentence in many of these cases, face a disqualification under Section 8 of the Representation of People Act for a period after his sentence is completed. Compare that with a situation here where Your Lordships are being told, oh, look, Parliament can expel. In Indira Gandhi's case, she was expelled in 1978. That expulsion was rescinded in 1980 because the House felt, oh, we need her back. Now, that can't be the arbitrary manner in which we leave what is a criminal process to the vagaries of the discipline of Parliament. Parliament will decide separately. That is completely different from a criminal prosecution. So it cannot be that if I have taken money for the purposes of a vote, that as long as I've taken that money and I'm walking on my way to Parliament, I am a guilty man on the streets of this country. The minute I enter the portals of Parliament, and I cast a vote, immunity. That is not at all the intention of the law. So you can't take something so tenuous and remote and say that we will link it now, it is connected to the vote. Because if that were so, every criminal activity that an MP or an MLA indulges in, he can say, oh, it was meant for the vote. I was just on my way to vote. I ran over somebody on the road, but I was on my way to go and vote. Also, there are some things which slip between gaps and it may come for interpretation at a later stage. Consider a situation where the whip of a particular party is told that, look, we have the whip tells is put under some kind of influence, whatever influence it is. And the whip is then told there's a threat or there's a bribe or whatever. Make sure that all these people vote in a particular fashion. Now, that is not technically, the whip's action is not a vote in parliament. The whip's action is not a speech in parliament. Now, could it then be said that the whip, when giving that instruction to his party members, has the immunity? This is a question that could arise. I'm just flagging it because many of these things will fall between two stools. Right now, we are looking at speech and we're looking at voting. But an instruction that goes from a whip to his party members to vote in a particular fashion may not necessarily be treated as one which is immune, because it is not technically a vote in parliament by the whip. It's an instruction that's being given, but it's so inextricably linked to the legislative process that maybe those kind of things will be on the margins. Those are not remote. Those are very close to it. But an illegal act can never be brought in, which is why, as I'll show your lordships later, if you take a broad interpretation of both in relation to and any, which are the words used here, you can bring anything which is remote and connect it to this and claim a cloak of immunity. As long as you keep it proximate, and for which this court needs to perhaps adopt what the majority in Brewster did. 197 of the CRPC, 19 in the Prevention of Corruption Act. The intentions are broadly the same. You have to protect people who are carrying out a function. Now, one is a complete immunity. One is another procedural thing where sanction will be given by somebody else. Now, when you are giving that sanction, can you say that, look, it was in the course of my work for me to take bribes, therefore I need to have a sanction? Your lordships have consistently said, and there is a judgment of the federal court, Justice Vaidyalingam's judgment, which everybody else agreed with in the early 40s, which has held a consistent position till today, through the 50s, through that Amroj Singh and all the way up to Prakash Singh Badal, etc., that those activities couldn't possibly have any relation with your public duties, your official duties. So you can't say that I need a 197 sanction for it. It's the same thing which applies here. You can't say that taking a bribe has anything to do with the legislative process. Your lordship will remember the phrase bartered a solemn trust. That is exactly what is taking place here. A solemn trust, that's in para 137 of the judgment. A solemn trust is placed in each of these representatives by the people of the country when they vote for them and elect them. They do not anticipate that they are going to betray my vote for you to do something which you have come to me at the hustings and said that as per my manifesto, these are things I'm going to do. You didn't add point 3A there. By the way, I will take bribes to vote. I will take bribes to ask questions. That's not part of it. I wouldn't have voted for you. So the bargain which underpins the democratic system is completely undone when you allow an individual to get away with that. And that is a betrayal of the solemn trust. So a bribe being given is a collateral purpose. The dominant theme or purpose throughout is effectively to weigh in on behalf of your constituents on a particular question or a speech that you're giving or a vote that you're giving. None of this can be linked in any way, my lord. And I won't read it out, but your lordships can see that the offense is complete on receipt. So the fact that I go and vote is completely unconnected. It's already an offense at that point of time. Once it is an offense at that point of time, an act which takes place or does not take place thereafter is irrelevant to this. The taking of the bribe is a full offense. Whether you're an MP or an MLA makes absolutely no difference. You cannot then go and say, I made a speech or I gave a vote and I've got immunity. Yes, ma'am.
What will be the situation, you're referring to section 7?
Yes.
Where there is an agreement
Yes.
that you vote in this particular manner or you speak in the parliament,
Yes.
and he performs as per the agreement,
Yes.
and thereafter he gets the money, the bribe which is agreed.
Yes.
That bribe is received after that.
Yes. If I can just read that section 7, the beginning part. I'm looking at the original section 7. Either way, whoever being or expecting, this page 99 again, whoever being or expecting to be a public servant accepts or obtains or agrees to accept.
That is true.
So the agreement is
Immunity
complete.
part of it. You are bifurcating it because
Yes.
immunity issue doesn't attach to it because the offense would have already happened the moment the money is already taken.
No. I'm not saying that.
In that second case also.
The minute agreement to
Therefore,
accept. So once the agreement to accept is there, it's complete at that stage. I shouldn't be doing that. As a public servant, I have no business accepting anything external to my public duties.
Proof is a big proof.
No, that's a question of prosecution. The minute it is launched under any of these sections under
Establishing the agreement, it says attempts to obtain also.
yes, or attempts to obtain, or attempts to obtain from any person for himself or for any other person any gratification. Now, please note, my lords, it includes expecting to be a public servant. So at that stage, it could include a situation who's not, a person who's not a public servant.
Correct.
So it includes, it's broad enough, and now they've split it up into ABC under the new casting. So I would argue, my lords, that the completion of the offense is at that point when I make a demand or when I enter into an agreement, it's over there.
But once you can get that.
Yes. One thing you may note is that, of course, this is a classic case, Narasimha Rao. If I may digress for a minute, I was in college when this judgment came out, and Professor K.C. Sunny, who was on the Cochin University, had set a moot problem, which we had occasion to take part in, where he merged Quixote Holland's facts and Narasimha Rao's facts. And as a first blush law student, it came as a shock to us that Narasimha Rao said what he did, and we had to try and justify it. Now, that judgment was very important, Narasimha Rao, because of the way it helps young students understand how ratios are called up. Because 3 judges are majority on one point, they are in 2 of them are in minority on another point, and they're unanimous on the 3rd point. So on this sanction point, I just want to show just a minute before you rise. Section 2C brings in that the competent authority will be the speaker and the chairman. But just see section 14 for a minute, Manoj. Section 14 is at page 2030, bottom of 2030. And there, subject to other provisions of this Act, the Lokpal shall inquire or cause an inquiry to be made. And B says any person who has been a minister of the union. C, which is at 2031, says, therefore, the interpretation that your lordships give will have a direct impact on how the Lokpal and the Lokayuktas, where the states have made the laws, will administer and implement the legislation with reference to corruption.